The Supreme Court recently granted review to the next big Second Amendment case, and once again it deals with state concealed carry bans and those restrictions that were passed in direct defiance to what the Supreme Court ruled in the 6-3 ruling in Bruin. And now that case is set to be argued in front of the Supreme Court in just a couple weeks. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. I highly recommend, if you want to support the channel, a free way to do that, of course, is to subscribe to the channel. Also double check to make sure YouTube has not unsubscribed you. They do that a lot without people even knowing, so just double check that as well. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be talking about a two-way case that is set to be decided by the Supreme Court this term. And once again, it deals with state concealed carry restrictions and laws passed in direct defiance to what the Supreme Court said in their 6-3 ruling in New York State Rifle and Pistol Association versus Bruin. And this case is currently set to be argued in just a couple weeks on January 20th. And this is going to be a landmark case going forward for the Second Amendment cause, and it's probably going to impact a lot of other issues. This case is called Woolford versus Lopez, and it's huge for everyone in states like New York, New Jersey, California, Hawaii, and other states who are currently living under these types of concealed carry restrictions, which were passed in response to Bruin. Recently, to the surprise of many, the Trump DOJ and AG Bondi actually stepped up in this case, and they called for this state concealed carry restriction to be struck down as unconstitutional. That may have also ultimately helped the Supreme Court to take this case and kind of break their track record of denying all of these emergency cases, because the Supreme Court did take this on an emergency basis. This is an interlocutory case. Traditionally, the Supreme Court does not like these types of cases at this posture, but this one they did grant, so this is an emergency case that the Supreme Court is set to rule on. Also, to the surprise of many, the Trump DOJ stepped up and they actually asked to participate during the oral arguments in front of the Supreme Court, and we're still waiting for the answer to the Supreme Court on that issue, but I anticipate really soon we're going to get the answer on that, and I would suspect the Supreme Court will allow the Trump DOJ to participate in those arguments. Now, also, you have 25 states that have filed a brief in support of striking down this concealed carry ban, but on the other side, you have 18 states that have also jumped in support of Hawaii and that concealed carry restriction, and also multiple anti-gun groups have joined that effort to keep these laws in place. And now all of these arguments have been distributed to the Supreme Court in preparation of that upcoming January 20th oral argument that's going to happen to them, and it's going to be very critical. Now, if you're not aware, this Woolford case is a challenge to Hawaii's new laws on concealed carry that were passed in direct response to Bruin. This law, like many others, tried to add more restrictions to concealed carry within the state and kind of create a default rule where individuals, even if you got a permit, it's essentially useless, because to enter any private property that's open to the public, you would have to get the express permission from that property owner. They would have to post a sign or maybe give you verbal consent, and it kind of flipped the paradigm on its head where usually, you would be able to go into all of these locations unless maybe they had a sign saying no guns allowed. But here, states like Hawaii kind of flipped that completely on its head and banned almost everywhere. This law was challenged by multiple plaintiffs, and they sued to strike down the law, and they also received a preliminary injunction which temporarily blocked that law from the lower court. Now, Hawaii decided to appeal that up to the Ninth Circuit, and the court reviewed this case along with the similar California concealed carry ban case, and on review, the Ninth Circuit upheld this catch-all property ban in the state of Hawaii. And then after that, the plaintiffs asked for the Ninth Circuit en banc panel to review this case, but that was denied. That then led this case to seek emergency Supreme Court intervention, and now the Supreme Court has granted review to this case, and they have set oral arguments to happen in just a couple weeks on January 20th. Now, the question that the Supreme Court will consider and answer in this case is whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public, unless the property owner affirmatively gives express permission to the handgun carrier. That means that the Supreme Court will directly address these catch-all property bans that were put in place and passed in direct defiance to what the Supreme Court said in Bruin. Now, one of the critical things that may have led the Supreme Court to take this case even on an emergency basis was that prior DOJ brief. And once again, like I mentioned, the Trump DOJ is jumping in support of this two-way effort. They recently submitted the amicus brief arguing that the ultimate decision of the Supreme Court should be to strike down this catch-all property ban. But the first thing that they also argued is that Hawaii's affirmative consent rule violated the Second Amendment because it was designed purely to suppress concealed carry within the state. They argue that this law here in Hawaii is not aimed to do anything like public safety or even to meet the claimed interest of the state of Hawaii, which was to protect the property rights of those individuals in the state of Hawaii. But really the ultimate purpose of this was simply to expand the gun-free zones and make almost everywhere within the state of Hawaii a gun-free zone, even if you had a concealed carry permit. They argue that property owners in Hawaii could already protect their rights by, engaging in things like trespass laws or posting signs saying something like no guns allowed, posting those type of signs. But here, really what they wanted to do is have the government step in and just ban almost everywhere within the state when it comes to concealed carry permits. And there was also a direct acknowledgement by some of the drafters of this law that very few business owners would opt into this kind of scheme and post the signs that say, concealed carry is allowed at this location. And the ultimate goal of that really, again, was to expand gun-free zones almost everywhere. So that's great news, and it would be likely beneficial to have the administration on our side during those oral arguments. It will likely also sway maybe some of those middle ground justices to rule in a pro-2A way. But also you have 26 states that have filed an amicus brief in support of striking down this Hawaii concealed carry restriction. So also you have a majority of states saying that this type of concealed carry law in a state is unconstitutional. But on the other side, you also have 18 states that have filed a brief in support of Hawaii's position and their arguments as well, and they argue that this new concealed carry restriction is permissible even under Bruin. Now, recently, Hawaii filed their response to the Supreme Court, and they argue that this law requiring consent before someone carries a firearm onto private property is fully consistent with the Second Amendment because the Constitution has never protected a right to armed entry without a property owner's permission. They argue in the brief that since the founding, the right to exclude has been a core feature of property ownership, and nothing in the Second Amendment overrides that principle. In Hawaii's view, the law does not ban carrying, instead it simply requires permission, which can be given verbally in writing or via some sort of sign. Now, this position is echoed by the 18 states that are joining in support of the state of Hawaii. They filed an amicus brief. Those jurisdictions and states include the District of Columbia, Illinois, California, Colorado, Connecticut, Delaware, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New York, Oregon, Rhode Island, Vermont, and Washington. In their view, flipping the presumption in favor of carry would force business owners to take affirmative steps just to keep firearms out of their locations, even though they already, in my view, had that ability to do that. They always had the ability to post a sign saying something like no guns allowed. But here what they're arguing for is for the state or the government to step in their position and create a default ban everywhere. On the Second Amendment question, the states take this kind of hardline approach. They claim that the right to bear arms simply stops at property lines. They argue that because property owners have an unquestioned right to exclude firearms, the government can step in and codify this exclusion as a default rule without implicating the Second Amendment at all. However, they fail to actually address how this approach allows the government, not just the property owner, to decide the default outcome. Again, they are letting the state and the government to step in the position of all property owners within the state and create a default ban. So this issue will now be heading to the Supreme Court for oral arguments on January 20th. The court has distributed all these arguments to the justices in anticipation of those upcoming arguments so they can look at all of this, as well as they probably, looking at the motion of the Solicitor General for the Trump DOJ, to argue during those oral arguments, participating in that, and we'll probably get the answer on that very soon as well about the Trump DOJ, participating in those oral arguments. But this is going to be a very critical case. This concealed carry case will be huge because it will be another case where the Supreme Court performs the Bruin text, history, and tradition analysis, and that will give further guidance to all the lower courts on how to handle these two-way cases. So that's what's currently happening in this critical case. In just a couple weeks, a landmark Second Amendment case is going to be argued in front of the Supreme Court. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Also, you can check out one of the two videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.